whether or not there is any prejudice suffered by the defendant as a result of the late disclosure. I'm interested in those two issues.
Your Honor, there are actually three items of concern to the defense with respect to our requests for sanctions. At the close of court yesterday, it was off the record, but we noted the problem that arose with respect to Mr. Goldberg's examination of Dennis Fung, and we were able to locate the transcript reference on October 5th.
Your Honor, I'm sorry, but if there's going to be something involving Mr. Goldberg's questioning of the witness, may I have a moment to get Mr. Goldberg either down here or watching upstairs to make sure that nothing's misrepresented, since I wasn't here and I don't know what he's talking about.
Well, counsel, I can't wait to conduct these proceedings for the attorneys to shuffle back and forth.
Well, Your Honor, I don't know if there was any notice that Mr. Uelmen was going to argue anything with regard to sanctions.
Well, when we left yesterday afternoon, it was brought up that reference was made to items that the court had suppressed at the 1538.5. So clearly there's going to be some severe sanction.
All right, Your Honor, I think I actually may be more familiar than Mr. Goldberg with the suppression motions.
All right. But I'm interested in talking about the tape sanctions first.
All right, I can address that issue first, Your Honor, and then address the question of the suppression and the also the investigation with respect to the shoes. The videotape was first revealed on March 24th, I'm sorry, and of course this was a tape that was made on June 13th. There were a number of informal requests that were not on the record with respect to the production of this particular videotape, and at the time of the late production of the videotape recorded of Mr. Simpson bidding farewell to the Brown family, concerns were also again raised with respect to the existence of any other videotapes, and a specific request was made at that time, I believe on the record, for any other videotapes in the people's possession that had not been turned over. I think you need to put this in the context, Your Honor, of the importance that videotape evidence has assumed in this trial. We saw a very good example of that with respect to the prior incident involving the videotape of the night of the recital at the junior high school, where witnesses had testified that Mr. Simpson that evening was hostile and uncommunicative, and then we saw a videotape in which we could make our own judgment and in which he appeared to be very friendly and bidding an affectionate farewell to his children and to members of the Brown family. So this evidence has crucial significance in terms of allowing the jury and the court to make their own judgments without having descriptions of events filtered through the testimony of witnesses who may have biases one way or the other. And in light of the record of the prior failure to disclose a video, the failure of the prosecution to produce this particular videotape until March 24th takes on a special significance, especially the fact that it appeared at a point in time when it somehow seemed to the prosecution's advantage to use the tape. So the explanation that this was inadvertently mislaid is a somewhat suspicious one in view of the fact that suddenly it is relocated and brought into court at the point in time when they feel there is some evidentiary use that can be made to bolster their case. And of course, the defense was deprived of any opportunity to use this tape in prior issues that were being litigated before this court. And in a number of respects, we believe that that irretrievably prejudiced the defense. First of all, this tape would have been of substantial use in litigating the motion to suppress evidence back in September, and it would also have been quite useful in cross-examining the detectives in charge of this investigation, because we have noted inconsistencies between the description of the discovery of the glove, for example, in the closet of Mr. Simpson's bedroom, as portrayed in the tape, where a single glove was removed, brought downstairs, put on a table, and appears in the videotape. That is not the way that incident was described in the affidavit for a search warrant, which was subscribed to under oath by Detective Van Adder back on June 28th. At that point, Detective Van Adder said, and this was the probable cause, you'll recall, to go back to Mr. Simpson's home and execute a second search warrant 2 weeks after the execution of the first warrant. The probable cause included the allegation that additionally, since the service of the first warrant, other officers present during that service have told your affiant that they saw another pair of gloves inside Simpson's residence. These officers had also seen the glove found at the murder location and have told your affiant that the gloves in the residence appeared to be of the same type as the one from the crime scene. Your affiant wishes to seize the gloves left in the Simpson residence because they will tend to further establish that the bloody gloves recovered belong to Simpson in that he favored this type, style, and size of glove. These gloves were inadvertently left behind at the Simpson residence. Now, we believe that cross-examination, both of Detective Van Adder and the detectives involved in finding that glove, would have disclosed additional misrepresentations in the affidavit for the second warrant, in that the videotape reveals one glove, whereas the affidavit refers to a pair of gloves. The affidavit says the gloves were inadvertently left behind when we have since been told that the detectives actually conferred with the detectives in charge and made a decision not to seize the glove. It was not an inadvertent leaving behind. They actually decided before they left the premises that they would not take this glove or these gloves, if there are two. So here we see significant areas for cross-examination that the defense was deprived of at the motion to suppress and in the cross-examination of the detectives, because we did not have this tape. We did not have the opportunity to see what this tape portrays. Now, clearly, there is a parallel, I think, between the failure to produce this tape and the failure to produce the tape involved in the cross-examination of Rosa Lopez. Because in both cases, Your Honor has been presented with a very similar explanation, that a detective inadvertently mislaid the tapes and that counsel were not aware that the tapes were in existence. And that's precisely the explanation we're hearing now from the prosecution. Despite that explanation, in the case of the Rosa Lopez tape, Your Honor concluded that severe sanctions were warranted. And those sanctions included fines imposed against both lawyers, a requirement of immediate corrective action to catalog all of the statements of witnesses and indicate when they were turned over to counsel, and a proposal to instruct the jury that the failure to produce this tape could be considered in assessing the credibility of the witness. We believe that if the court is going to be even-handed in the administration of sanctions, that precisely the same sanctions are warranted here, that Your Honor should order corrective action be immediately taken to require that the prosecution immediately catalog all videotapes in their possession or in the possession of the police with a description of those tapes and an account of when they were turned over to the defense. Secondly, we have proposed a jury instruction that closely parallels the instruction that Your Honor proposed to give with respect to the testimony of Rosa Lopez, informing the jury that the laws governing criminal procedure in California require disclosure of evidence in advance, that the reason these laws exist is to promote the ascertainment of truth, to save court time, and avoid the necessity for interruptions and postponements, that the delay in the production of this tape from June 13th until March 24th was a violation of the law and the cause of delays in this trial during the week of March 27th, and that the jury may consider the effect, if any, of this delay in disclosure upon the credibility of the witnesses involved in the gathering of evidence on June 13th. That would closely parallel what the court ordered in the case of the Rosa Lopez tape. The second issue that is of concern to the defense with respect to sanctions involves the very late production, again on March 24th, of 238 pages of investigative material relating to the prosecution's attempt to identify locations in which shoes matching the shoe print left at the crime scene were sold. This investigation took place in August and September of last year, and apparently the prosecution deliberately decided that they would not turn over any of this investigative material until their investigation had been completed. So all at once, on March 24th, the defense is handed 238 pages of material, much of which is in a foreign language. There is correspondence in that file in Japanese and Italian that we're going to have to get translated. We're going to have to conduct some follow-up investigation ourselves, and we believe, once again, we have an example of the prosecution simply withholding vital evidence until it's too late for the defense to do any investigation of their own. We believe that at a minimum, the court should delay the presentation of any evidence relating to the identification of footprints until the end of the trial, that the court should require immediate disclosure of any follow-up investigation. We need to know just as quickly as possible what the net results of all of this were, whether they are going to be presenting any evidence identifying the source of any shoes, and we need to know that right now so we can begin to prepare to cross-examine so that we
The results of the FBI testing on the shoe prints was turned over to you within a day of the court receiving it from the FBI.
What we're talking about here, Your Honor, is the effort to connect that particular shoe pattern with the sale of shoes at particular locations. I mean, this really relates to the effort of the prosecution to try to tie that shoe to Mr. Simpson. We are not aware of any evidence that in any way connects shoes of this nature with Mr. Simpson. And if they're going to put on any such evidence, engage in any attempt or inference to suggest that shoes of this type were purchased by Mr. Simpson, we need to know about that, and we need to be prepared to meet that evidence. At this point, we have seen nothing, we have heard nothing, except this 238 pages of material that was turned over just 1 week ago. We would ask at a minimum that the presentation of this evidence be delayed and we be given any follow-up investigation that came in its wake. The third item, Your Honor, relates to the direct examination of Mr. Fung at the close of our proceedings yesterday. And as I mentioned, we have located in the transcript the court's ruling on October 5th, 1995, pages 2395 to 2396 of the transcript. Here I'm reading from the statement of the court. All right, search warrant number 2, items 15 and 16, the ticket receipt and baggage tag. And I think Mr. Uelmen was correct. I think the prosecution has the burden as to these two elements. Ms. Clark, that's correct, Your Honor. With respect to items 15 and 16, the prosecution will not be seeking to admit them. The court, all right, then we will take items 15 and 16 and note that they will not be offered. The representation is that they will not be offered. In the event that position should change, then the defense is entitled to a de novo hearing on the 1538 during trial if that becomes necessary. And yesterday, in violation of that agreement, Mr. Goldberg elicited from Mr. Fung testimony with respect to the seizure of both of these items, the airline ticket receipt and the baggage tag. We believe that this is a very egregious violation of counsel's duty to deliberately elicit testimony and evidence that the prosecution agreed would not be offered in frustration of the defendant's rights to seek suppression of that evidence. And we believe, once again, that severe sanctions are warranted, including the giving of an instruction to the jury. And we have fashioned a proposed instruction. We would propose that the court instruct the jury as follows. The laws governing criminal procedure in California require the exclusion of evidence that was unlawfully acquired by the police. These laws exist to protect the privacy of all citizens by deterring unlawful police conduct. Prior to the trial of this case, the prosecution represented that some items of evidence would not be offered in the trial, and the court withheld a ruling whether they were lawfully acquired. During the testimony of Mr. Fung, the prosecution violated their agreement, and you may consider the effect, if any, of this violation upon the credibility of Mr. Fung and give to it the weight to which you feel it is entitled. Your Honor will note that this instruction closely parallels the instruction that the court proposes to give with respect to Rosa Lopez. We also feel that a fine would be appropriate as a sanction in this case as well. Your Honor, in the moving papers with respect to sanctions, the defense has made a proposal to in effect call off this escalating war of sanctions, which is frequently characterized by hyperbole and over-dramatization and personal vituperation, and simply put over to the end of this trial, after all of the evidence is in, all of the issues with respect to what punitive sanctions are warranted in this case. While the court must, of course, immediately address questions about needs for delay in the presentation of evidence or arguments with respect to the total preclusion of evidence, we believe that preclusion is not a remedy that is going to be seriously considered with respect to any evidence in this case, that the court will more often be dealing with issues involving fines and retaliatory jury instructions. Of course, we're hopeful that the court will never have to deal with any of these issues again, but that hope certainly has not been warranted up until now. We believe there would be three very good advantages to the court in putting these issues over. First of all, it could expedite the presentation of the evidence to the jury, which is sequestered, and avoid the interruptions and distractions of arguments about sanctions that seem to be coming up with recurring frequency. But more important, it would allow the court to assess the issue of prejudice, the issue of willfulness, and most important, the issue of the extent to which jury instructions of this nature might undermine the reliability of the truth-finding process in the context of the entire trial, in the context of what the defense has done, what the prosecution has done, what pattern of willfulness emerges, and what degree of prejudice emerges in the context of the entire trial. I think it's interesting that in the few appellate cases considering sanctions pursuant to California's reciprocal discovery law, there have been some reversals of the imposition of sanctions, but the appellate court has the virtue or the advantage of looking at the effect of the sanctions in the context of the entire trial and how those sanctions affected the fact-finding process that was ultimately handed to the jury. There is no reason on earth why a trial court should not have the same advantage and should not be able to look at this whole question of sanctions in the context of what impact it had throughout the trial before the final instructions are given to the jury. And if Your Honor feels that instructions are necessary, those instructions can then be incorporated into the final instructions to the jury. We believe that the third advantage this would give the court is even-handedness, that Your Honor would be able to assess the relative culpability of the defense and the prosecution at the same time and balance the scale of what sanctions are appropriate with respect to each side. In that respect, then, we would request that Your Honor withdraw the order that you entered on March 1st with respect to sanctions relating to the Rosa Lopez tape and simply put over this question of sanctions to the end of the trial and address all questions of punitive sanctions and retaliatory instructions at that time. But if Your Honor is not so disposed and feels that each sanction issue should be addressed as it occurs, we would alternatively request the instructions that we have asked for with respect to the June 13th videotape, with respect to the elicitation of evidence that the prosecution agreed would not be offered and should impose fines as sanctions.
Thank you. Ms. Lewis.
Your Honor, good morning.
Morning.
Your Honor, I believe this area of discovery violations and sanctions needs a reality check, and that reality check has to be based on the discovery laws, because as those discovery laws point out, the only orders requiring discovery that shall be made in criminal cases are as provided in this chapter. Now, the provision of the Penal Code 1054.1 requires the prosecuting attorney to disclose to the defense a variety of materials, but the preface to the disclosure of these materials is that they must be disclosed if it is in the possession of the prosecuting attorney or if the prosecuting attorney knows it to be in the possession of the investigating agencies. The defense has failed to even make that threshold showing, which is required before any of these other issues, whether that's material, whether it's Brady or so forth, even becomes of issue. They have failed to make that threshold showing. It's uncontroverted that we did not know about this tape until March 24th. It's uncontroverted. We did not have this tape in our possession.
This was the problem, though, is that throughout this litigation, it has been brought up that the defense says, we know there's another videotape because we have information from the news photographers that there was some police photographer videotaping. Where's the videotape?
Your
And
Honor,
the representation was made that it didn't exist. That's the factual basis.
Well, the basis is we made inquiry. I was personally present when inquiry was made of the lead detectives in the case, and they were unaware of its existence, excuse me, and therefore told us that nothing existed. And it's clear why they were unaware of its existence, because all of the evidence elicited yesterday supports that this was a tape made solely for administrative civil liability purposes. The tape is, not only did Detective Harper, Detective Looper, the videographer, and Mr. Atkins' supervisor all testify that that was their understanding of the purpose of this tape, but the tape is self-authenticating in that regard. It does not show the pathway where the glove was recovered from. It does not show the blood drops on the driveway. It focuses extensively, I counted about 4 to 5 minutes, on all the trophies and the valuables within the trophy room. It shows the furniture within the residence. It shows the cars within the grounds of the residence. It shows all of these items of value, and it even shows the only damage or apparent damage, which was these 2 blood drops on the light wood floor, also for civil liability purposes.
But doesn't that contradict the testimony regarding when those blood drops were collected?
I don't know why Your Honor feels it does. I don't see any contradiction in that, Your Honor. There's no item numbers shown next to those blood drops, so presumably they were collected prior to this videotape being shot. I don't see a contradiction.
Well, if they're still there, how are they collected?
Well, I imagine it's a stain, blood stains. I don't think it could be completely removed from that light-colored wood floor.
Well, I assume those light-colored wood floors have a sealer on them.
Well, I don't think we can assume things like that, Your Honor.
Well, I stood on the floor.
Well,
Counsel.
I did as well, and I frankly don't recall whether it seemed to have a sealer or not, but I think that's a big leap to make, to say that because a tiny portion of this 25-minute video shows what turns out to be criminal evidence or evidence relating to the criminal investigation in the case, therefore this video becomes material in any constitutional sense or in any sense at all in terms of defense discovery.
Well, the problem I have, though, Ms. Lewis, is this. The request was made several times by defense counsel that they knew or had reason to believe that this tape existed. And they asked several times for it. And we got representations back several times. It doesn't exist.
Your Honor,
Now we find it exists.
it was our belief that it did not exist, and it is understandable how that happened, since it was made for this purely administrative purpose and was placed by Detective Looper, who's not been part of the discovery process, is not one of the lead detectives in the case, was placed by him in a file cabinet because and he only thought of it when it became known to him that he was going to be testifying in the case. So that's when he thought of it. That's when it occurred to him to look for aids that might be useful in refreshing his recollection during his testimony. He thought of it. He brought it to the attention of the lead detectives. They immediately told us. We immediately had it copied as soon as our lab was available. It was a Friday, I believe, that we discovered it, and we turned it over the following Monday. It may be unfortunate that this tape was not depicted sooner, but there's an additional point to be made. When you talk about defense prejudice, even assuming it was discoverable, and it was not, Your Honor, and I don't care if they made specific requests, if we had not planned, now that we know about this tape, we would like to use parts of it. We would have liked to have had it months ago and used parts of it in various other hearings. But even at this point in time, if we did not intend to use that tape at trial, it would not be discoverable. I don't care if they personally requested it or made a specific request for it. This is not Brady material. And in fact, under Brady, there need not be a specific request made. So that when we're talking about sanctions, Your Honor, and we're talking about imposing sanctions on the prosecution, that is a serious allegation and a serious matter. And it was serious for the defense, it's serious for us, but we're in a different context than the defense was in the Rosa Lopez matter. I'm going to talk about that in a moment. We're in a situation where we had no obligation to provide this discovery. If we had known about it, we would have. Of course it would have been useful in examining the witnesses. It would have been useful during direct examination, not just cross-examination by the defense. We would have liked to have had this video, but we did not. And the fact that we do have discovered it now is simply to everyone's benefit. It doesn't mean that there was any prejudice inured to the defense. They failed to show any prejudice whatsoever in not having it. And along those lines, the photographs that the defense has had in their possession for months are actually much better evidence, as Detective Looper, I believe it was, alluded to when he testified yesterday, because the photographs show this evidence when it was recovered, after it was recovered. It shows all of these blood drops. It shows everything in better detail because those photographs were taken indeed for criminal investigation purposes under perhaps under subdivision C of Penal Code Section 1054.1. Those are real evidence intended and shot for the purpose of criminal investigation purposes. So those photographs were discoverable. They were turned over. They're certainly the best recordation, much better than this video, of all of the crime scene evidence and the locations where items were recovered. The photographs show the pathway, the glove, and so forth. They show the criminal aspects of this case. They don't show all the valuable Heisman Trophy and all the other valuable trophies that the defendant had because those were not part of the criminal investigation in this case, and there was no reason for those still photographs to depict them. The only thing that is shown on the videotape, which is not shown on these crime scene photos, that might have had some significance was the linen closet, which was fingerprint dusted. But as Detective Looper testified yesterday, no fingerprints were recovered. There was nothing of evidentiary significance about the linen closet, and I don't believe the court has heard any testimony. I don't recall in the months I've been involved in this case any testimony having to do with the linen closet because there's been nothing relevant about it. So there is nothing on this videotape that is not better depicted, much better depicted within the photographs the defense has had for months. Now, Your Honor, the Rosa Lopez situation is entirely different. The defense, under Penal Code Section 1054.3, Subdivision A, requires, the law I should say, requires the defense to turn over the statements of witnesses they intend to call at trial, recorded statements, recorded in any manner. The Rosa Lopez was on the defense September 1st, 1994 witness list. So their intention to call her at trial was clear and present for months before that tape was discovered. Now we have the defense would like to draw us into this, and it's the same situation as they're in, but we're not. The discovery statute, when it talks about if it's in the possession of the prosecuting attorney, or if the prosecuting attorney knows it to be in the possession of the investigating agencies under 1054.1, which is the statute that covers our obligation, makes that critical distinction between us and the police.
Do you think the 1054.1, that a reasonable interpretation creates an obligation for the prosecution to make reasonable inquiry and diligent search for these items?
We did, Your Honor. We did. We wanted...
No, I'm not asking you whether or not you did.
Well,
do you agree that a reasonable interpretation of that code section
yes,
requires inquiry to be made?
Yes. I think that is a reasonable interpretation of that code section. But unlike that section, the defense, the section governing the defense obligations, discovery obligations, makes no distinction between the defense attorneys and the defense investigators. And that's clear why. The police department is a separate agency, a separate entity. It's not even a county department. It's a city department. We're in total different forms of government or totally different bureaucracies. We don't pay the police. We don't order the police around. The police aren't beholden to the DA's office. We don't pay their salaries. They have similar goals that we do in terms of some criminal prosecutions, so of course we work in conjunction. But it's a different situation when you look at the defense side of the table. Their defense investigators are employed directly by them. They do take orders directly from them, and that distinction is recognized in the discovery statutes by the failure of the statute governing defense discovery to make any distinction between the defense attorneys and their investigators. So when it came to the Rosa Lopez tape, the defense attorneys were charged with the knowledge of that tape that Mr. Pavlik had in his possession. Not so with us, and that's not so because of the express terms of the statute. So we're talking about apples and oranges. In addition, of course, the defense, when it comes to the civil liability aspect of this particular videotape, the DA's office wouldn't be sued if the police had seemed to have done something to cause damage to those premises. The Los Angeles Police Department would be sued, and they have been sued. And they do have the choice now, the detectives have the choice of recording either by videotape or by still photos locations where search warrants are executed to make sure that they've got a record of that in case of a later suit. I'm sure the court's aware the departments suit all the time. So they have different administrative liabilities and problems than does the DA's office. I guess we get our own lawsuits in some respects, but certainly nothing to do with the execution of search warrants. And, Your Honor, the defense keeps talking about this recital tape. We're not talking about the recital tape anymore. The court made inquiry about that, of the June 12th recital that the defendant attended. The court made inquiry. We didn't know we had it. Apparently, I don't remember exactly how that came about because I wasn't personally involved with that. But when we found it, we turned it over. It certainly was not material evidence. And, and the court has to consider that this, as I said, even...
Ms. Lewis, how can you say that it's not material evidence where the prosecution's theory is that there was this tension and anger expressed by the defendant on the date in question at the dance recital, and that he was glowering at people and was in another emotional state of mind, and yet we see him greeting the Brown, or saying goodbye to the Brown family and smiling and greeting his children. I mean, that's directly contradictory to the testimony of the prosecution witness. So how can you say that that wasn't material?
No, to the contrary, Your Honor, it directly supports the entire prosecution theory. When Mr. Simpson was inside that auditorium, when he wasn't in the public domain where people would be looking at him, he's thinking about other things, that's when the witnesses testified as to those expressions. When he got outside, was aware, greeting people and was aware, that became his public persona. And as Mr. Darden told the jury during opening statement, this man has two personas. He has the public face and he has the private face.
All right, let's move on to the FBI shoe print matters.
The defense, Your Honor, has still failed to show how these materials fall under the discovery laws. As I indicated to the court the other day when this whole issue first came up, these materials are basically correspondence. They're materials sent out by the FBI to manufacturers in an effort to investigate this whole shoe area.
Do you plan on calling Bill Bodziak?
Yes.
Aren't these his work material and his reports and his efforts to investigate?
Well, these are investigative efforts. I would call them investigative efforts. And they have now been turned over. But, the investigation is ongoing. We may not have seen the end of the shoe evidence. It is ongoing today as we speak. There are people investigating this area. And, I don't want to fill the court in on the details, but...
Well, the problem I have, though, is that these reports go back to August of 1994. These
are not
letters,
reports.
this correspondence.
Your Honor, these are not reports. Let's make that clear. These are not the reports of experts, and they're not even the experts' notes. It's correspondence as part of the investigation. I'd invite the court to take a look at what we're talking about, because this material clearly does not fall under the discovery laws. We've chosen to make it available, give it to the defense, but even the cover letter from the FBI indicates that they've reviewed all the discovery requests directed to the FBI and unless otherwise noted, have complied with each of them, even though many are clearly outside the normal scope of discovery. That's the letter from Mr. Shapiro, the general counsel for the FBI. So he's saying that we're going to give you everything, even though it is outside the normal course of discovery. And, as Mr. Goldberg actually pointed out the other day, because we've been so generous in this case and have, well, I'm not sure he pointed this out, I won't lay it on him, but I'll make the point, that because we have been so generous in this case and going through hoops and providing the defense with an incredible amount of discovery, way beyond what we were ever required under the law to do, they're turning around trying to slap us in the face with it. We've given them too much. This stuff is not even discoverable. If we'd not given it to them, they would have not known about it. Here they have it weeks in advance of any evidence coming on with regard to the shoes. They have it when they don't even have to get it, and we gave it to them as an extra courtesy. But, let's go back, Your Honor, as we've made the point in previous motions, we did provide, I think it's over 23,000 or maybe more by now, pages of discovery, hundreds of videotapes, audio tapes, et cetera.
Let me ask you this, Ms. Lewis. I only was provided with a few what were deemed by the defense to be representative pieces of that 238 pages of material regarding the shoes from the FBI, which seemed to indicate a search to identify that particular sole pattern, is my recollection of what I read. Have you identified, to your knowledge, that shoe pattern?
We've identified the shoe pattern, yes, as being that of a Bruno Magli shoe, Bruno Magli. Indeed, Your Honor, the defense was provided with the reports and the final discovery and what is discoverable. These, when it comes to experts, not the whole world's discoverable. As the court knows, the court did a lengthy in-camera. I'm assuming that we prosecutors did not get every bit of information. I'm sure the court made a careful evaluation in determining what was discoverable and what was not. And in this case, it was obvious to us clearly that this is material which is not readily discoverable. It's not provided, and we did provide the bottom line reports with regard to those shoe prints.
What I was getting at is Ms. Lewis, is what is the materiality of the items that were turned over? What is there?
There is no materiality of the items that were turned over. I'd be happy to lodge. This happens to be our only copy, but we can make a copy, or I'd lodge our
All right,
originals.
would you have your staff make a photocopy of that and lodge it with the court so I can read it?
I'd be happy to do that, and we'll do that, Your Honor.
All right, would you address the testimony of Mr. Fung regarding items that were withdrawn by the prosecution?
I will, Your Honor. I had one final point I wanted to make. I wanted the court to be aware that its favorite language in the Augers case was not overruled by the Bagley case, as the defense, Mr. Thompson, Mr. Thompson, the defense attorney, made the representation the other day. The Bagley case reaffirms Augers and talks about when something is considered constitutionally material. But even in the Bagley case, it was undisputed that the material was Brady material that was at issue in that case. There were contracts with prosecution witnesses and as far as what payment they would receive, depending on how much information they gave. So that was clearly and obviously Brady material. But there has to be a showing of constitutional materiality, Your Honor, for something to be discoverable under Brady, and there's nothing even close to that in this videotape. And I'll reiterate the point that the stills photographs show better everything that the video show better because it shows not only during the early time, but
Counsel,
later
you've made that point already.
I
What I'm
realize that, Your
interested,
Honor. All
what I'm
right, with
interested
the court's permission, since I wasn't present yesterday, and I know what the issue is, but Mr. Goldberg would like to address the court with regard to Mr. Fung's testimony.
Morning, Your Honor.
Morning, Mr. Goldberg.
Just to clarify the record, I think to my recollection it was Mr. Scheck that made the comment about Augers being recalled. I nodded at the inappropriate time while Ms. Lewis was looking to me for affirmation. I think it was he and not Mr. Thompson, so I did not want to have the court misled in that regard. Not that it's that particularly important. On the issue of the testimony by Mr. Fung, this is a situation, Your Honor, where the prosecution immediately upon realizing, specifically me upon realizing, that question should not have been asked because it was eliciting information that had been suppressed, instantly agreed with the defense that it should not have been asked, it should not have been elicited, and Ms. Clark agreed. So this did not require any argument, it did not require looking at the transcript, and I just don't understand why Dean Uelmen would feel that it is necessary to go back and argue from a legal perspective something that we had immediately conceded unless he's interested in simply the public excoriation of the prosecution, or in this case, of me. I just don't understand the necessity of that. I would agree with the Dean that there has been an escalation in terms of requests for sanctions, perhaps because the defense, in our view, was legitimately sanctioned for some very serious discovery violations in instances where there was at least circumstantial evidence, strong circumstantial evidence, I believe in the court's opinion, that there was either intentional or negligent misrepresentations that were made before this court. regarding issues that went right to the credibility of
Well,
material
let's
witnesses.
put those other issues aside as being apricots and oranges at this point.
Well,
My interest here is, given the agreement of the prosecution to withdraw those items, how did this happen?
Well, Your Honor, the way that it happened is very simple. I was not here when that happened. As the court knows, I was a relatively speaking recent addition to the prosecution in this case. There are a large number of issues that were litigated, and I did not know about that. It was not communicated to me. It was an error. It was a mistake. We made a mistake.
Doesn't the prosecution have some obligation within the team members to communicate with each other and organize the presentation of this case?
Of course, Your Honor, and we have done that. But does the court honestly believe, I'd ask this question rhetorically, that I am going to ask Ms. Clark, were the airline tickets suppressed? I mean, of course I have been communicating with her about my presentation of the case and all the tactical issues and how we're going to present it. I think that Your Honor recognizes that. But no, I did not ask her whether the airline tickets were suppressed. And if I should have, and I failed to, then I made a mistake. But I did not ask that question. Sorry, they were not suppressed. They were litigated, as Ms. Lewis just pointed out. What I would say on this issue is my sole reason for asking that question was not because I thought there was anything relevant or material per se about them, but I simply wanted to get the sequence of events, particularly as it related to Detective Van Adder giving the blood vial to Mr. Fung. I wanted to be very careful in terms of our presentation of that part of the evidence and what sequence of events occurred and what pieces of evidence he collected just before he left and received that vial. The airline tickets themselves, it would seem to me, based upon what the jury has heard of this, if anything, would be something that would be somewhat favorable to the defense in the sense that it would seem to indicate that the trip was a planned one as opposed to being unplanned. So it certainly doesn't have any evidentiary value in terms of the content of the evidence as opposed to the timing sequence as far as the people are concerned. And from a legal perspective, when the issue of an instruction to the jury is raised, what I would point out to this court is that it is a well-recognized principle of law that unless an objection is lodged, the objection is waived. And there was no objection by counsel. I don't know. They haven't even represented to the court in good faith that they didn't intend to introduce the evidence themselves of the airline tickets. So they didn't object to it. They didn't do anything until they discussed it at sidebar with Your Honor and with Ms. Clark and myself.
At the end of the day.
At the end of the day. But they didn't object at the time when an objection could have been sustained to the question and at a time when any evidence could have been precluded. So legally speaking, I think that we would be entitled to take the position from a legal standpoint that there's nothing more for the court to do. That's not the position I'm taking. If the court wants to admonish, if the defense wants this, that question and that answer is struck, we would concede that that is an appropriate way of handling it. Legally, it may not be necessary, but we would concede that that is an appropriate thing for the court to do. But to give an instruction of the kind that that Uelmen is proposing doesn't make any sense. And the only reason that I compared this alleged violation to certain of the other violations that Mr. Uelmen discussed is because he drew a comparison, and he was analogizing to the instruction that the court was proposing to give for the Rosa Lopez incident. And they are not analogous, because what happened in the Rosa Lopez incident is that the prosecution was deprived of, until the last minute, materials that were very significant in terms of the cross-examination and the credibility of that witness. There's been no analogous violation by the prosecution with respect to Mr. Fung. What has happened with Mr. Fung is I asked him a question that he had absolutely no way of knowing was improper, and he answered it as he's required to do as a witness. It in no way reflects upon his credibility. It in no way reflects or diminishes the capacity of the defense attorneys to cross-examine Mr. Fung effectively, or deprives them of materials to make their cross-examination effective, or deprives them of the opportunity to have a sufficient period of time to examine those materials. So you're not dealing with any of the problems that you are in the case of Rosa Lopez, where discovery was held back on some very important statements that she made that we used for the purposes of impeachment. I don't know whether the court wants me to address the issue of fines. I will if the court wants to hear about that.
Well, it's something that might happen, so this is your chance to say something.
Okay. As to the issue of fines, first of all, in the criminal context, there is no statutory authority for the imposition of crimes to the same extent that there is in the civil context. It's been a while since I've practiced any civil law, but the Code of Civil Procedure does provide for the imposition of fines for a wide variety of things in addition to discovery violations. I believe that a court in a civil hearing can fine counsel for making frivolous motions. Perhaps some viewers of this case wish that the court had the authority to do that here. But there is case law to indicate that the Code of Civil Procedure sections dealing with fines do not apply in the context of a criminal case. What we do have now in the post-Proposition 115 context is a specific provision in 1054 for fines for discovery violations, but that's it. So legally, there is no basis for fines outside of that area, unless the court were to hold the prosecution or me in contempt and then to fine me that way. But other than that, there's no authority for the imposition of a fine.
Don't you think I have authority under CCP 177.5, the court having ordered that before any new mention was made by the prosecution, that notice was to be given to the defense, and that they were then entitled to a de novo 1538.5?
No, that's what I'm saying is I don't believe that the Code of Civil Procedure sections apply in a criminal context with respect
All
to
right, well,
fines.
the case law is pretty clear that I have authority under 177.5 to impose fines.
I'd have to look that up then, Your Honor, because I thought I read a case several years back that said that the court did not. But I may be mistaken about that, so I don't want to represent something based upon my recollections of a case that I read a very long time ago.
All right, well, just so you understand, it's my position that I have the ability to impose sanctions up to $1,500.
Okay.
And I feel comfortable with that.
Okay. If the court were inclined to do so, I'd like an opportunity to go back and find that case, because I do have it in my computer. Unfortunately, it's at home. And I did not know that counsel was going to be asking for fines, because when we had our little discussion, it seemed like Mr. Cochran and I think maybe Mr. Shapiro was there, felt that this was not a major deal and that a lot more is being made of it than was yesterday evening. The other thing I'd say on the issue of fines, it has to do more with a practice in our legal community than with the actual law, and that is that I'd like to point out that the prosecution did not request fines of the defense attorneys in this case as a result of the discovery violations. And there are a number of reasons that we didn't do so, and I'm not in any way criticizing the imposition of fines by this court. But it is our feeling that it is not appropriate in that kind of a situation for an advocate to ask for fines against another advocate, even for something that amounts to an intentional or reckless misrepresentation, and that was our reason for not doing so. I'm not in any way commenting upon the imposition of fines by Your Honor. We're just saying what our position was and why we didn't ask for that. I believe, based upon my practice, that there is an unwritten rule that fines are generally not imposed and generally not requested by criminal practitioners in our local legal community.
But it's a sanction that the court has available to it to maintain order in the court and to maintain respect for the orders that the court makes. So it's a sanction that the court uses, not necessarily at the request of the parties.
Well, I was just explaining to Your Honor why we did not request it, and I'm also explaining why we are somewhat surprised by the fact that Dean Uelmen has requested this, and somewhat surprised by the fact that the defense has requested it in general.
Well, they didn't like the fines that they got. That's the basis for that. I
But
understand.
I'm just saying that we did not ask for them. I was pointing that out. Yes, Your Honor is right. You do have the capacity to maintain order, But what I would suggest on that issue is, how is it going to maintain order of this court by imposing a fine? How is it going to deter any future violation of something that we are entirely unaware of and that a reasonable person would not have made inquiry into? You know, yes, I did discuss my aspects of the case with Ms. Clark, but as I said, Your Honor, I did not ask specifically whether the airline tickets had been suppressed. And if the court is concerned about deterring future incidences of this kind, I don't see how the court can deter that kind of unintentional mistake. It is not the first mistake that has been made in this case. It won't be the last. There are going to be other issues that come up by both sides. I think we know that, and that is a fair statement based upon what has happened here heretofore. So I'd ask the court to consider all those issues, but more importantly on the issue of an instruction, because that would adversely impact the interests of our client, the people, and adversely impact the credibility of this witness if the court were to give any instruction of the kind that Mr. Uelmen has proposed. That is simply entirely unfound from a legal perspective, from a common sense perspective. It in no way relates to this witness's credibility. That information that was agreed not to be elicited was put before the court. And we would ask the court simply to tell the jury that the question and the answer to the question are stricken.
All right, Dean Uelmen, 10 minutes.
Listening to the response of counsel was somewhat of a deja vu experience. We were hearing lots of echoes of the argument that preceded the court's imposition of sanctions against the defense. The I wasn't there defense. I recall that Mr. Cochran's declaration to the court indicated that he came into the case later, that he did not direct the activity of Mr. Pavlik as his explanation of why he wasn't aware that the tape existed with respect to Rosa Lopez, that we didn't know it existed defense.
Well, let's not relitigate that issue.
All right. Well, there's one thing that wasn't echoed, Your Honor, and that was any expression of contrition. No apology. In fact, defiance. In fact, the suggestion being made that we've been overly generous in what we've turned over to the defense. Your Honor, there's an attitude problem here. And frankly, the response of the prosecution, I think, should create greater alarm for the court. It certainly creates greater alarm for us than existed prior to hearing what they had to say. I mean, the suggestion that whatever the police have in their file cabinets, we have no responsibility to inquire into except to ask them if they have it, that this is not Brady material, that evidence of the significance of the videotape of Mr. Simpson's demeanor on the day that the murder took place, 3 hours before the murder took place, that's not Brady material. That this tape shown the very day after of the condition of the premises and showing the blood spots, and you know, the suggestion that this was just an administrative videotape just doesn't wash. If there was any concern that the people or the police or the prosecution might have had that there would be some liability for the premises, the condition in which they left Mr. Simpson's premises, you would have we would have had a videotape showing the plumbing job in which they actually removed the drain pipes from some of the plumbing, from the sink in Mr. Simpson's bedroom. That's not even on the tape. What is on the tape is a portrayal of gloves, a portrayal of blood spots, items that are of great evidentiary significance in this case. And I think what we see is an attitude that just doesn't recognize that there is an obligation to make this kind of evidence available to the defense. And we would seriously suggest that perhaps Your Honor needs to order that the prosecution have a look at what's in the file cabinets. I mean, the suggestion that police can just put things in the file cabinets and we don't need to worry about what's there, frankly, we're worried. We're more worried now than we were before. If these two items that have shown up tardily are an example of what else may exist in police files, we think Your Honor should order the prosecution to make a complete examination of all of the evidentiary items and reports in the possession of the police department, and that Your Honor, if there is any question at all, should yourself examine this material and apply a true standard of what Brady requires. Apparently the prosecution just doesn't have any conception of what their Brady obligations are. Now, with respect to the specific items here, the videotape, first of all, Your Honor is correct that the specific inquiry was made as to the existence of that tape. So what we have here is conduct bordering on willfulness, certainly conduct showing recklessness, and certainly no greater showing of willfulness than existed with respect to the Rosa Lopez tape.
Are you seeking the suppression of the tape?
No, we are not. We are not asking for preclusion with respect to this tape. We believe there is evidence in this tape that is favorable to the defense that we may want to use. The prejudice we're asserting, though, is that we got it so late that we couldn't use it in our motion to suppress. We couldn't use it in cross-examining the detectives in charge of the investigation, and counsel didn't even address the question of the inconsistencies between what this tape suggests and what the search warrant affidavit suggested. So we believe we have made an ample showing of prejudice with respect to the failure to produce this tape at an earlier point. With respect to the investigation of the shoes, the explanation that an investigation is ongoing does nothing. In fact, it suggests, once again, that the prosecution interprets their obligation as simply doing their investigation, and then when they're done, turning over the results of their investigation.
No, 1054.7 provides the means to shield confidential matters if it's necessary to do so to complete an investigation. That argument doesn't fly.
Okay.
So don't waste
and
your
they
time
should
with
have come to you and
Don't waste your
sought
time
that.
with it.
All right. With respect to the relevance of that material, for us to do follow-up investigation, there's a lengthy chain of distribution that the prosecution is attempting to track down, showing what manufacturers were allowed to use this pattern, which of those manufacturers exported to the United States, where in the United States shoes that have this pattern were on sale. There's a lengthy chain of distribution that we are going to have to retrace if, in fact, they are going to offer evidence to suggest somehow that these shoes were available for sale in the United States in a place where the defendant might have acquired them.
Do these 238 pages deal with that?
They do. They do indeed. They are inquiries to specific manufacturers, to specific distributors in an attempt to track down where these shoes were distributed and sold. And finally, with respect to the issue on the suppression, I think it goes without saying that any counsel who comes into the case is going to have to familiarize himself or herself with the prior rulings of the case. I mean, if the defense or the prosecution can just bring in a new lawyer and ignore prior agreements and rulings of the court, and then when called to account say, well, I wasn't here when that happened, there's no way that this court can conduct a reasonable trial. The objection was made immediately after the close of court yesterday, and as I recall, these were the last questions addressed to Mr. Fung at the end of his testimony yesterday. So certainly I don't think we can suggest that the defense waived this issue by not making a prompt objection. We believe that simply striking the question and the answer does not communicate the degree of egregious misconduct by counsel involved in asking and answering these questions. Now, Mr. Goldberg says, well, an instruction doesn't make any sense. To tell the jury that they should consider this with respect to the credibility of Mr. Fung makes no sense because it has nothing to do with the credibility of Mr. Fung. That overlooks the nature of the jury instruction as a punitive measure. The failure to promptly disclose the tape involving Rosa Lopez didn't have anything to do with her credibility either.
Yes, it does.
It does not, Your Honor.
Yes, it does.
I respectfully suggest that the tape was produced, they did have it, and they were allowed to use it for cross-examination.
Which is precisely why it goes to her credibility.
The tape goes to her credibility.
Absolutely.
Right. But does the delay of the defense in disclosing the tape go to her credibility?
And that's for the jury to decide.
That is for the jury to decide as a punitive measure, to punish the defense for not producing the tape. And by the same token, we would say it's for the jury to decide what credibility they should give Mr. Fung's testimony when the prosecution deliberately elicits evidence and testimony that the pretrial agreements provided were not to be elicited.
All right, counsel, wind it up, please.
All right. With respect to the fines, again, we're simply asking that the court be even-handed and address the question of sanctions from the same perspective that you addressed them with respect to the defense counsel. In fact, we have suggested much more modest fines because we do not want to deprive the prosecutors of the means to come to court suitably attired. But I can certainly loan them some sackcloth. I think they'd look good in it at this point, certainly better than I would look in a dress. To conclude, Your Honor, I think, frankly, the best way to handle this whole situation is simply withdraw the order of March 1st and put over to the end of the trial all issues of punitive sanctions, so Your Honor has the benefit of a full record of the conduct of counsel throughout the trial at the time you address these issues.
Thank you, counsel.
Your Honor, just for the record, there was no plumbing torn up or taken or done anything else with on the 13th.
All right, the court will make the following order immediately. The district attorney's office is ordered to prepare and submit to the court by the close of business April 7 an inventory of all video tapes that are in existence either in the possession of the district attorney's office, the Los Angeles Police Department, or any other agency that is involved in the investigation of this case. The district attorney's office is ordered to prepare and submit to the court by the close of business Friday an inventory of all reports, letters, and other items regarding the shoe evidence. Court will take under submission the request for sanctions, monetary sanctions, as to all three of these items. And Mr. Uelmen, will you submit to the court the draft language of your instruction regarding the ticket and baggage receipt?
Your Honor, videotapes, could you, the order be a little bit more specific, because there is news footage, I think, that, I mean, our
Videotapes.
Media Relations Department has taped this case for days and days and days, so
Inventory of all videotapes. All. Friday, noon.
including all the news shows we've taped for the last several months. I don't mean to be impertinent, it just is a...
All videotapes. Each and every one. This is the second time the prosecution has popped up late with a videotape.
This one was not in my possession, I've already made that point.
But we knew it existed and inquiry was made several times.
Well, we didn't, as I told you, we did not know it existed.
Well,
Detective Looper did, but we didn't.
Detective Looper's part of the prosecution team, I take it.
Not under the penal code section covering our discovery obligations, Your Honor.
I agree. I think the prosecution's very fortunate that that statute was written by prosecutors.
That's by the voters of this state, Your Honor. That was initiative that the
Oh, I
voters
agree, and
approved of.
that's the disability that the defense has, because the defense obligations are spelled out much more clearly than the prosecutor's obligations are. It's an interesting statute. All right, we'll take a 10-minute court reporter recess, then we need to take up the presumptive test issue. I'd like to see counsel in chambers for the 10-minute recess. I want to know what your position is on the presumptive blood test. All right, back on the record in the Simpson matter, the defendant's again present before the court with counsel. People are represented. We have one more matter we need to resolve before we invite the jury to join us. That is as to the prosecution's offer of presumptive blood tests. Mr. Goldberg.
Oh, I see, it's coming right now.
Ms. Lewis.
Our media relations director asked for me to have the court acknowledge what to me is obvious. That is the tape that the inventory of tapes the court wants would be from June 12th, and of course only tapes relating in some manner at all to this case.
That's correct.
Thank you.
Your Honor, I had an additional citation that I wanted the court to look to, and it's Professor Uelmen's treatise on scientific evidence, and specifically page 532, which discusses admissibility of preliminary blood testing and discusses the phenolphthalein test, and also cites Coleman, which I previously cited to the court. And the reason that I'm bringing this to the court's attention is because I believe that his interpretation of Coleman is the same as the interpretation that I offered to the court when I first cited it. And I'll also give a copy to counsel. May I approach?
You may. Thank you.
Your Honor, may I make one comment before you sign?
All right, who wishes to be heard first?
Just very, very briefly,
Could I beg the court's indulgence to make one more brief comment on the other matter? The drain at the defendant's residence was, the trap was removed on the 13th, and that was the extent of the plumbing, whatever that was done. I just clarified that with Mr. Fung himself.
I heard it was more extensive than that.
Your Honor, not for the purpose of argument, just to clarify what is the issue here, and that is that the people wish to introduce evidence of a presumptive positive in a phenolphthalein test. So we're dealing here right now with the phenolphthalein test, and we're dealing with their request to introduce evidence of the positive result. One of the things that I pointed out, Your Honor, is that a negative result is of a completely different nature. It is a conclusive test. It means that there couldn't possibly be blood there. So to lump the admissibility of negative results with positive results for the phenolphthalein test really raises a completely different issue.
What negative results do we have?
They did presumptive testing on stains all over the place. For instance, they saw reddish stains along the south wall of the house. The police did.
What negative results do we have?
Those were negative.
All right.
Those were negative. There's allegations of certain stains found in other places in the house as well, at Mr. Simpson's house. They tested those. Those were negative.
All right. What's the nature of the plumbing? You indicated that false positives come from copper plumbing. What's the nature of the plumbing at the Simpson residence?
I don't know. I can't answer that question right now. I have not examined the plumbing. But the main problem, frankly, with false positives for a phenolphthalein test, Your Honor, isn't even the copper. It's microorganisms and bacteria. And that's why I've called out to leading forensic scientists around the country, and they don't even use the phenolphthalein test for anything involving plumbing fixtures. They would take the residue or whatever it is that they want to test back to the laboratory and do confirmatory testing, which could assess what the item is. That wasn't even done here. Unlike the other items that they wish to introduce, there was some corroborative or confirmatory testing done. But as the Blake article points out, microorganisms and bacteria which live in wet, moist places, such as drains, render the usefulness of a pheno test under those circumstances to be absolutely useless. So that's what gives rise to the 352 issue as well, Your Honor. That's why we're not opposing, for instance, the pheno result and the photograph depicting it of the stain on the floor of the bathroom.
Because that stain was collected and then tested, correct? All right. Mr. Goldberg?
What I'm hearing from the defense is somewhat troubling. What they say is, well, we can put in evidence of the negatives because, as the court will recall from Mr. Cochran's opening statement, he made a big point about blood not being located in certain places. So they want to create this inference buttressed now by scientific testimony that they're graciously not objecting to as to negatives in a variety of places, without also showing evidence of positives in other logical places that one might expect to find blood if a defendant who had just committed murders had come back to his residence, had gone upstairs and stripped of his clothes and taken a shower. That is the height of giving the jury a completely skewed and erroneous view of the evidence. This is a legal question for the court to decide, and it's a very simple legal question, and that is the admissibility of presumptive tests. But before I address the law once more on that issue, which we believe is clear in the state of California, I just asked the court to view it also from a common sense perspective, because we know that a person can come into court, a lay person, and testify that something appeared to be blood or even was blood, that's an appropriate lay opinion. We can ask Mr. Fung, who has some expertise, whether something appeared to be blood, and that kind of an opinion is far less reliable, obviously, than a forensic test. We also know in our courts that a narcotics officer can come in and testify that in his opinion something was in fact cocaine for the purposes of proving that it was cocaine, even where there has been no chemical testing. In fact, there was a case, People versus Sohnleitner, that I was just thinking of as I was listening to counsel speak, where cocaine was flushed down the toilet before the narcotics officer could seize it. And he testified that in his opinion it was cocaine, and the court held that that was fine. It's somewhat analogous to the issue we're doing here. So we do allow people to express opinions that are not based upon scientific tests or evidence, that are far more subject to dispute than the kind of scientific evidence that we want to put in. Yet that is allowed. And the ambiguities of those opinions and the fallibility of those opinions is an issue of weight for the fact finder. We don't have to be overly concerned in our system of law of trying to shield the jury from this kind of information when they're going to hear both sides. They're going to hear what kind of false negatives you can have. They're going to hear under what conditions you can get an erroneous result. And they're going to hear the kind of experience that Dennis Fung has had in using these tests and the problems with the tests, which he is qualified to speak to because he is aware of the kinds of things that create false positives, and he has looked at some of the literature in this regard. Now, to address the California law just very briefly on the issue of forensic blood testing or presumptive blood testing. We do believe that Coleman is dispositive, and all they are saying is that, yes, these do come in, yes, there is a history of them coming in, but you have to have evidence as to what test you're using. Because in that particular case, it was a police officer, not a criminalist, and all he said is that it was a heme stick, or hemo stick, and no one knew what that was, or the Supreme Court couldn't make any decision as to what that was. But we know very clearly that phenolphthalein is one of the oldest tests. It goes back all the way to 1909. It's the most specific test, according to the literature. It's based upon the same principle as the rest of the presumptive tests, including the ones that the defendant's own experts used. And very clearly under California precedent, it should be admitted. And any issues as to the ambiguity go to the weight of the evidence, and that's a jury issue for them to resolve.
But don't I have a 352 problem that if it's only a presumptive test that hasn't been confirmed and that it's can be triggered by commonly occurring substances as well? And given that this is likely to turn out to be a circumstantial evidence case, I mean, isn't that really a waste of time?
Well, we're obviously spending more time litigating the admissibility than the evidence would take to come in. The kinds of things that could create a false positive are vegetable peroxidases, which are found in a number of vegetables, common vegetables, including apple. But
Not likely to be in a bathroom drain.
right, exactly. I mean, unless maybe he was pouring apple juice down the drain. There are also a number of other chemicals that are not commonly household chemicals, and this would be the subject of Mr. Fung's testimony. But even as to the vegetable peroxidases, it's very clear that while it is theoretically possible to get a false positive, that an experienced criminalist can distinguish between a false positive and an actual positive, because what evidently happens is it does turn pink, the same pink color that a true positive would, but it's much slower. And this is also documented in the scientific literature.
What about common household bleach, though? Which one would use in
I don't believe that,
Common.
and I may be mistaken about this, but I'm not sure that bleach was one of the items that could result in a false positive.
the article that you submitted to me indicates that bleach is one of the chlorine bleach is one of the items that can create a false positive, which is not uncommon in bathroom fixtures.
Yeah, according to Professor Winkery, he does say that. Of course, this isn't a scientific text, but it's a legal text. And as I said, there are other things that do cause false positives. But, and maybe perhaps we could clarify this point with Mr. Fung, because I don't know if I specifically asked him about bleach as opposed to vegetable peroxidases. I don't recall having done that. But I do remember his explanations to me about the vegetable peroxidases, and I can't represent to the court that his explanation would be the same with respect to bleach.
Well, how do we compare the case law here in Coleman with the case law dealing with luminol?
California case law dealing with luminol?
Yes.
Which case is the court referring to?
Out of curiosity, why we're not, I can't find the case at the moment.
Your Honor.
But let me ask you this, why were no follow-up tests done on these items?
What are you going to test to follow up? I mean, in order to collect the stain, there has to be something that you can see, according to my understanding. And there are certain instances where the only evidence you're going to have is the phenolphthalein test. Another instance where we have that, for example, is on item number 11,
All right.
which was the wire.
Now, let me ask you this. Wouldn't the better practice have been to take the trap out of the plumbing fixture?
I think that he may have taken the trap out, according to what we saw, and I don't know if that would be the better practice. I'd have to.
Was that tested?
Excuse me?
Was that tested?
I don't think so. Or there was. Let me take a look. I'm sorry, there was a test on that, and the trap itself was negative. I mean, so the only that's the evidence that we have. I mean, we looked for evidence, and the only evidence that we have
So isn't it
is the
logical that if
phenolphthalein.
blood was being washed down the sink, that more of it would be in the trap than on the rim of the sink?
I'm not a plumbing expert, Your Honor, so I can't answer that one. I was informed by someone who apparently knows more plumbing than I that you don't make drain pipes out of copper. I don't know that to be true, but that's what someone told me. Getting back to the luminol question that the court asked, I'm not familiar with the California cases the court has cited. I'm familiar with some out-of-state cases that,
All right.
that deal with that. But can I just make one more point about luminol? Luminol isn't as specific, is nearly as specific as phenolphthalein, and there is literature to document that fact. And the point that I was trying to make yesterday when I was talking about the two-stage process is that you did not always have two stages on the phenolphthalein test. When it was first invented in 1909, I believe that they just applied the phenolphthalein solution, if I'm not mistaken. They now add the hydrogen peroxide, and evidently that is supposed to deal with and negate some of the problems that you'd otherwise have with the vegetable peroxidases.
All right, thank you,
And that
counsel.
distinguishes it from luminol.
All right. Nope. Proponent, opponent, opponent. All right, counsel, as to I'm going to direct the prosecution to cover up the two photographs on the exhibit. All right, the two items that were missing, that were agreed not to be introduced were the airline ticket and what, a baggage tag?
Your Honor, may we have a few moments just to patch that exhibit, because as the court knows, I didn't want to.
All right.
was not found in any locations except those where there's been specific evidence of it, such as item number 14 and item number 12 inside the house.
No, they would do that at the peril of opening the door to all these other things.
The question was, we cannot argue or suggest in questions that there's no blood in the places where they did the tests. Okay. Other places where there's plainly no blood, we can bring up.
You can bring that up.
Fine.
But if you create a false impression
Right.
that that was not tested,
Oh, no,
then
absolutely.
you open the door to all manner of mischief.
Yep.
No.
You see, Your Honor, the problem is that what they're intending to do and what they've already done is to create a false impression. Because what they're going to say is that the only places where we have evidence of blood are 14 and 12.
If they argue that, then you get to reopen your case. They won't argue that. Don't create false impressions.
Right. But we can argue that, for instance, they did a pheno test some other place and it was negative.
Correct.
Well,
Thank you.
of course, allowing the negative pheno testing.
Counsel, your own authority says that the absence of a positive pheno test is conclusive that there's no blood. That's the authority you've cited to the court.
I was inquiring.
This is not a quid pro quo. Let's proceed. Ms. Clark, I've already ruled on this. We're not arguing this.
I was not allowed to address the proposed instruction. This is the first time I'm seeing
Excuse me,
it.
counsel, but I thought we had complete argument on both sides on this issue. We have, trust me.
We had argument, but this proposed instruction is just now being shown to me. Are we allowed to address this issue of whether the proposed instruction is correct or fair?
Counsel, you had more than ample opportunity to address it.
How's that, Your Honor? This is the first time I've seen it. How could I address something I've never seen?
Counsel, during the course of the argument, Dean Uelmen asked for this instruction. Then Ms. Lewis was given the opportunity to respond. Here we are.
And Mr. Uelmen then wrote down what he proposed that the court actually give with respect to a luggage tag of no prejudicial value at all. I mean, we are losing perspective here, and I've never seen the proposed instruction he just wrote until this moment. We have not had a chance to address it.
Counsel, you had the opportunity to address it. Would you return it to the court, please? Thank you. Let's have the jury. Some of you are still smiling. My apologies to you for having kept you in the small jury room for such a long time. And I want to advise you that I'm going to change our procedure in dealing with so many of these pretrial matters that I have to take up before we invite you to join us. I'm going to schedule all further hearings on these type of matters at 4:30 at the conclusion of the court day, so that we'll get more time in front of you as far as the jury is concerned. Yesterday, something occurred at the conclusion of the court day that I need to instruct you regarding. The laws governing criminal procedure here in the state of California require the exclusion of evidence that was unlawfully acquired by the police. These laws exist to protect the privacy of all citizens by deterring unlawful police conduct. Prior to the trial of this case, the prosecution agreed that some items of evidence, specifically the airline ticket and baggage tag, would not be offered into evidence at trial. During the testimony of Mr. Fung yesterday, this agreement was violated. You shall therefore disregard the testimony of Mr. Fung regarding the airline ticket and baggage tag. You must treat it as though you had never heard it. All right, let's have Mr. Fung. All right, Mr. Fung, would you resume the witness stand, please? All right, good morning again, Mr. Fung.
Good morning.
Mr. Fung, you're reminded you are still under oath. Mr. Goldberg, you may continue with your direct examination.
Thank you. Good morning. Before we get into the issue of the evidence processing, once you got back to the lab, I wanted to clarify a few things that occurred earlier on the day of the 13th. Can you tell us, Mr. Fung, what time it was that you left Rockingham for Bundy on the 13th?
I left Rockingham for Bundy at approximately 10 o'clock.
And when did you arrive at Bundy?
I arrived at Bundy at 10:15 in the morning.
Okay. Now, when you returned to Rockingham in the afternoon, did you have occasion to see stain number 8 again that afternoon, the same one that you'd seen earlier in the morning?
Yes.
And was there anything different about the stain when you saw it in the afternoon than when you'd seen it before?
Yes. In the morning, the stain was a reddish color, and when I returned in the afternoon, it was a dark brown color.
And is there a distinction between red and brown in terms of the age of the stain in your mind?
Yes.
And what happens when it starts aging a little bit?
When a stain ages, it starts to degrade.
Okay. So it had turned brown by the time you had returned.
Yes.
Now, regarding the stains that were collected at Rockingham in the morning of the 13th, were there any of those stains which you did not personally see being collected?
When I refer to my notes?
Yes.
I did not personally see stains 7 and 8 collected.
Had you seen them, though, prior to the time that they were collected and during the documentation phase?
Yes.
All right. And at Bundy, were there any stains there that you personally did not see collected?
Yes.
What stain or stains?
Would be stain item number 52 with the photo ID number 117.
Was 52 the stain that was at the end of what you referred to as being the trail?
Yes.
Okay.
You may. Counsel, the request was to see what he's referring to, not to have a private conference. Proceed.
Sir, what document were you referring to in order to provide the answers with respect to the stains that you did not personally witness being collected?
I referred to a crime scene checklist, and I also have some other notes that I have created for easier testimony in my notebook.
Okay. And when you were testifying about stain 52 at Bundy, I can't recall whether you may have already testified to this, but did you participate in documenting and measuring where that was?
Yes, I did.
Okay. With respect to the stains that were collected at Bundy on July the 3rd of 1994, when were those booked into evidence in LAPD? Do you have to refer to something to give us the date?
Referring to my property report,
Tell us the date of the property report you're looking at in order to give us this information.
the date of the property report is July 5th, 1994. And the items were booked into the evidence control unit of SID at July 5th, 1994.
Okay. And when you book something into the evidence control unit, is it sealed prior to that time?
Yes, it is.
And regarding item number 9, the glove that you discussed yesterday in your testimony, did you see any stains on the paper bag into which it was placed?
No.
Okay. Did you see any wet blood in the area, excuse me, did you see any wet or dry blood in the area where that glove was found?
I did not observe any.
Your Honor, at this time I'd like to put up the Rockingham diagram just briefly. That would be People's 169.
Good thing there's no wind in this place.
Mr. Fung, I'm directing your attention to what's been marked as People's 169 and is titled Rockingham Interior Biological Evidence. Did you have the opportunity to look at this exhibit prior to the time it was brought down to court?
Yes.
Right. And directing your attention to the call-out number that says 14, what does that show? What area of the residence is that showing?
That is in the master bathroom.
Okay, so that would be depicting the upstairs of the house?
Yes.
And what do the photographs that are attached to item 14 show?
The photograph on the right depicts Criminals Mazzola displaying the results of a phenolphthalein test, and the photograph on the left is a close-up, and you can see the stain here.
Okay, you're pointing to an area that's just to the right on this photograph, about 1.5 inches or so from the card.
Yes.
And is the other photograph to the left simply a perspective shot demonstrating the same general thing?
Yes.
Now, directing your attention to the item call-out number 13, what general area is being pointed to there with that call-out line?
That is the master bedroom.
What about the two photographs that attach to that call-out line? What do those show?
Those two photographs show a pair of dark-colored socks on the throw rug.
Those are the socks that you recovered and listed as item 13.
Yes.
And now finally directing your attention to the call-out line that says 12, what general area of the house is that pointing to?
That is, those two photographs depict the foyer of the house, which is the entrance, and there are 3 large stains on the floor. And that is, a close-up of that is shown in the right picture.
So the right picture is simply, or the left picture rather, is simply a perspective shot showing the same general item as the picture on the right.
Yes.
Thank you. Now, we had left off yesterday with you going back to the laboratory, and I believe you testified that you arrived at approximately 6:30, is that correct?
Yes.
Right. Now, when you went back to the laboratory, were you still wearing the same gloves that you had, that you would have been wearing at the time that you left Rockingham in the afternoon?
No.
What process do you go through in the laboratory when you're returning to the lab with biological evidence?
With biological evidence, there's a drying process that type of evidence is subjected to.
Your Honor, at this time I'd like to mark as Peoples 170 for identification another board, and I believe it's entitled Evidence Drying Demonstration.
All right, People's 170.
Yeah. Sir, direct your attention to the board that we've labeled 170. Perhaps we could see the first photograph on that in cell 1. Sir, what does that show?
The first photograph depicts the door to the evidence processing room.
Okay, and is that's an interior door?
Yes, it is.
And EPR stands for Evidence Processing Room?
Yes.
Is there any other door that you can take into that particular room?
Yes, there is.
Which door is that?
That is the rolling door that faces towards the outside of the facility.
And in order to get the rolling door up, do you have to go through this door?
Yes.
indicating the door that's depicted in cell number 1?
Yes.
All right. If you look at this picture in cell number 1 to the right of the door, there appears to be some sort of a plastic or glass-like object. What is that?
That is a marker to let people know where the most sensitive part of the sensor for the keyless entry is.
So is this like a card key type entry system?
Yes.
All right. Was Andrea Mazzola still with you during the trying process that occurred on the 13th?
Yes.
Right. Now, let's take a look at a photograph in cell 2. What does that photograph depict, Mr. Fung?
The photograph depicts the transferring of a cloth swatch in a plastic baggie to a labeled test tube.
Your Honor, at this time I'd like to mark a test tube as Peoples 163 G.
163G.
Sir, I'm showing you what's we just marked as 163G. What is that item?
This is a disposable test tube.
And I'm going to take a item that we've previously marked as Peoples 163E for identification. It's one of the plastic bags contained in that coin envelope. You testified that this was the type of plastic baggie that you use when you're at the crime scene?
Yes.
Can you just show us how it is that you're manipulating the evidence as is depicted in cell 2 by using the test tube and the plastic baggie?
Yes. Well, first I would have gloves on, as is depicted in the picture. The cloth swatch would be within the bag. I would place the test tube in the plastic bag and manipulate it into the test tube.
Okay. So your hands never come into contact with the swatch itself?
That's correct.
Is that the procedure that you used on the 13th in terms of drawing?
Yes, it is.
And who did all of those manipulations? Was that you or was that Andrea Mazzola or a combination?
Ms. Mazzola labeled the test tubes, and I did the actual manipulation of the cloth swatches into the test tubes.
So all the manipulations you did.
Yes.
Now, when you say labeled the test tubes, what kind of label is put on there?
The same number that is placed on the coin envelopes are placed onto the test tubes.
How many coin envelopes do you work on at a time when you're doing this procedure?
Only work on one at a time.
Okay. And what happens to the control that's in that corresponds to the stain in a particular evidence, not evidence, but coin envelope?
The control is treated in the same manner and placed in its own test tube with the number and the letter C next to it, denoting that it is the control for that item of evidence.
Is it generally easy to recognize the difference between the control and the stain, even without the reference to this letter C?
Yes.
Why is that?
Generally, the cloth swatches that have the stain on them are dark red in color, and the controls are not red. They're either white or very close to gray or white.
Now let's take a look at the cell that's number 3 on this diagram, Peoples 170. Mr. Fung, what is portrayed in this cell?
Once both the control and the item with the stains on them, or the cloth swatches with the stains on them, are transferred to the test tubes, both the control and the evidence is placed back into the original coin envelopes with the open end faced outwards and placed into a box top.
I don't know how good the resolution is on cell 3, but if you take a closer look at that, can you see how many test tubes are in the envelope that's being placed down by the glove hand?
Yes,
How many is that?
there are two.
Okay, so one would be for the control and one would be for the stain.
Yes.
Now, if you have more than one stain cloth swatch in a case where you applied several in order to collect the stain, where do all those go?
All those go within one test tube.
Okay, so you have one test tube that has all of the stain swatches
Yes.
and one test tube that has the control or controls.
Yes.
What is the purpose of this box that the item is being placed into?
The box is used for storage of, or a transitory storage stage to move from the table to the drying cabinet.
Okay, now let's take a look at cell number 4 on People's 170. What does this show, Mr. Fung?
That depicts me placing the box with the items of evidence into the drying cabinet.
Okay. And on the 13th, did you use this same procedure that you've just outlined with us using this demonstration exhibit?
Yes.
Right. Thank you. Now, after the items are placed in the storage cabinet for drying, what did you do?
That night, after the samples were prepared for drying, I went back to Northeast Station where my car was.
Did someone have to drive you there?
Yes,
Who was that?
that was Criminals Missoula.
Do you know approximately how long this drying process occurred before Ms. Mazzola drove you back to Northeast Station?
Not more than 10 minutes.
Now, sir, on June the 14th of 1994, at approximately 8:30 in the morning, did you receive another piece of evidence from someone?
Yes, I did.
And who was that? If you have to refer to something, tell us what you're looking at.
I am referring to my property reports